It starts quietly, too quietly for something that has been building for more than 2 decades. On Wednesday morning, inside a London courtroom that has seen its share of history, Prince Harry took the witness stand. No procession, no spectacle, no royal fanfare, just a chair, a microphone, and a man about to speak under oath about stories most people thought were long finished. Before we continue, please hit the like button, subscribe to the channel, and turn on the notification bell for updates. That alone should make you pause. Because this isn't a celebrity revisiting old grudges. This isn't nostalgia dressed up as justice. This is a collision between memory and power, between how news was made 20 years ago and how it is judged today. And the uncomfortable truth is that once you start pulling at that thread, it doesn't stop with one prince, or one publisher, or one courtroom. It pulls at the entire machinery. Here's the contradiction that should sit with you from the start. The stories at the heart of this case are old. Some are more than 20 years old. They were published, read, debated, and then folded into the background noise of public life. And yet on Wednesday, they were treated as if they were brand new. Not because of what they said, but because of how they may have been obtained. That's the tension. That's the unease. That's why this matters now. When Harry began giving evidence, the question was not simply whether journalists crossed legal lines. It was whether time itself can excuse methods that no one questioned back then, or whether those methods look very different when examined under modern scrutiny, inside a courtroom, under oath. And maybe more unsettling than that. Whether silence at the time meant consent, or simply powerlessness. From the outside, it might be tempting to dismiss this as yet another chapter in Harry's long-running battle with the British press. Another lawsuit. Another grievance. Another headline. But that reading misses something important. Because this case doesn't begin with Harry. It begins with a system. A system where private moments became public currency. Where information appeared in print with such specificity that the only logical question was, how did they know that? And where the answer, more often than not, was simply shrugged away. Sources. Tips. Good journalism. End of discussion. Until now. Inside the High Court, the atmosphere was procedural, almost restrained. There were no dramatic speeches. No theatrical exchanges. Just questions. Carefully phrased. Slowly building. Each one designed not to provoke emotion, but to establish something far more dangerous. Patterns. Harry's role here is specific. He is not a prosecutor. He is not a commentator. He is a claimant, accusing the publisher of the Daily Mail and its sister newspaper, the Mail on Sunday, of unlawful information gathering, of either carrying out or commissioning activities that crossed legal boundaries in order to produce stories about his private life. That phrase matters. Carrying out or commissioning, because it widens the frame beyond a single reporter, or a single phone, or a single act. It suggests a culture, a workflow, a set of assumptions about what was acceptable, what was deniable, and what would never be examined closely enough to cause trouble. The publisher, for its part, has not hedged. Before the trial even began, it issued a statement calling the accusations preposterous and without foundation. Not mistaken, not exaggerated, preposterous. It insisted that its journalists did not commission or obtain information derived from illegal activity, that the stories were the product of responsible journalism, based on legitimate sources, and that many of them were published 20 or more years ago, without complaint at the time. That defense is simple, almost elegant, and potentially devastating if it holds. Because if the court accepts that argument, the message is clear: history stays where it is. Practices are judged by the standards of their era. Silence becomes absolution. And those who lived under intense media scrutiny but lacked the power or knowledge to challenge it at the time are simply out of luck. But if the court doesn't accept it, if it decides that legality doesn't expire, that time doesn't cleanse methods, that no complaint at the time doesn't mean no wrongdoing, then this case becomes something much larger than Harry versus a newspaper group. It becomes a warning. That's why this trial is scheduled to run for more than 2 months. That's why both legal teams agreed to a detailed schedule stretching to March 26th. And that's why the judge, Matthew Nicklin, is expected to reserve his ruling for later. Because this isn't about speed. It's about precision. Every question asked of Harry on Wednesday was designed to probe not just what he remembers, but what can be reasonably inferred. Memory, after all, is slippery. especially when it spans decades, especially when it intersects with trauma, youth, and relentless public attention. And the defense knows this. One of the quiet strategies unfolding in this courtroom is the tension between lived experience and evidentiary standards. Harry can describe how it felt to see private conversations appear in print. He can point to moments where information surfaced that, in his view, could only have come from unlawful activity. But feeling isn't proof. Suspicion isn't documentation. And the law is not interested in vibes. It's interested in connections. That's where this case becomes uncomfortable to watch. Because the court isn't just listening to Harry. It's listening for gaps, for assumptions, for places where outrage fills in what evidence cannot. And yet, and this is crucial, absence of evidence is not evidence of absence. Especially when we're talking about alleged practices that, if they existed, were designed not to leave trails. Deleted records, unlogged transactions, conversations that were never written down. So what do you do with that? Do you dismiss the claim because the paper trail is thin? Or do you ask why the trail is thin in the first place? This is the question hovering over Wednesday's testimony. And it's why every pause matters. Every careful word. Every moment where Harry seems to choose restraint over certainty. He is not claiming to know everything. That, in itself, is notable. He is not presenting himself as an omniscient narrator. He is saying, instead, this is what I experienced. This is what appeared in print. And this is why I believe those things are connected. Belief, however, is not the same as proof. The defense is counting on that distinction. Counting on time. Counting on the fact that these stories were once consumed without objection. Counting on the public's fatigue with media versus royal narratives. But courts don't run on fatigue. They run on standards. And the standard being tested here is whether large media organizations can be held accountable years later for how they gathered information, not just what they published. That distinction is subtle, but it's everything. Because publishing is protected, gathering is regulated. This is where the case becomes a slow burn. There are no explosive revelations in the opening days. No smoking gun. No moment where the room gasps. Instead, there is accumulation. Article by article. Date by date. Method by method. A legal attempt to show that what looked like coincidence may actually have been consistency. That's not easy to dramatize. Which is why this trial is easy to misunderstand. It's also why Harry's presence on the stand matters. Not because he is royal, but because he is a living archive of a period when press practices were aggressive, competitive, and largely unchecked. When scoops were currency and ethical boundaries were flexible. Ask yourself this. If you were a teenager or a young adult and intimate details of your life appeared in the national press, would you know how they got there? Would you know your legal options? Would you even imagine that challenging a major publisher was possible? Or would you assume, as many did, that this was simply the cost of being visible? That assumption is at the heart of the publisher's defense. That if no one complained, nothing was wrong. That responsible journalism speaks for itself. That legitimacy doesn't need to be retroactively proven. But history has a way of revisiting those assumptions, especially when other scandals, phone hacking, unlawful surveillance, covert information gathering, have already shown that what was once dismissed as paranoia sometimes turned out to be policy. Harry's case does not exist in a vacuum. It sits in the shadow of those revelations. And while this trial is not a rehash of past scandals, it is undeniably informed by them. Which raises another uncomfortable question. Are we looking at isolated behavior or a broader ecosystem that normalized boundary pushing because it worked? The court will not answer that in one day, or 1 week, or even by March 26th. But Wednesday mattered because it set the tone. It established that this is not a performance. It is a methodical examination of how stories are born, and whether some births involved acts we are no longer willing to excuse. As the day progressed, the questions narrowed. From general claims to specific articles, from feelings to frameworks, from outrage to inference. And that's when it became clear that the real battle here isn't between Harry and the press. It's between two ideas of accountability. One that says the past is the past, and that journalism should be judged by the standards of its time. And another that says legality doesn't age, rights don't expire, and silence under pressure doesn't equal consent. The judge will eventually decide which idea prevails in this case. But long before that ruling arrives, something else is already happening. The way we think about old headlines is changing. Because once you ask how a story was made, you can't unask it. Once you start looking at patterns instead of punchlines, the spectacle fades and the machinery comes into focus. And that's where things get dangerous for everyone involved. Because what comes next in this courtroom won't hinge on outrage or sympathy. It will hinge on whether patterns can be proven, whether time can be challenged, and whether the absence of complaints really means the absence of wrongdoing. And once that door opens, it doesn't stop with one prince. It never does. What does it actually mean when a prince takes the stand? Not the symbolism, not the optics, the mechanics. Because once you strip away the title, what you're left with is a witness, sworn, constrained, interrupted, answering questions in a room that has no interest in narrative, only sequence. That shift matters more than it looks. Wednesday did not begin with drama. It began with logistics. Papers arranged, voices lowered, time marked not by headlines, but by procedure. And in that quiet, something subtle happened. The story stopped belonging to the press and started belonging to the court. Prince Harry walked into the High Court not as a symbol of celebrity grievance, but as a claimant whose credibility would be tested line by line. Not admired, not defended, tested. That distinction changes everything. The first thing you notice, when you study accounts of the room, is how deliberately ordinary it all feels. No raised voices, no grand statements, just a steady, almost surgical rhythm of questioning. This isn't television drama. It's something slower, more unnerving. Because in a courtroom like this, the danger isn't what's said loudly. It's what's said carefully. Harry's evidence unfolded in fragments. Not confessions, not monologues. Answers, short at first, measured, often qualified. He didn't rush to certainty. And that restraint, whether strategic or instinctive, immediately set the tone. This was not a man trying to relive old wounds for effect. This was someone navigating a legal minefield where overstatement could be fatal. And that, in itself, is revealing. The opening questions were deceptively simple. Identity, role, context, establishing who he is in legal terms, not public ones. The court doesn't care about memoirs or interviews. It cares about standing, about why this person, in this room, has the right to make these claims. Once that foundation was laid, the questions edged forward, not into allegations yet, into experience. What did you read? When did you read it? How did it make you feel? Those questions sound soft, almost therapeutic. They're not. They're laying groundwork. Because before you can argue unlawful conduct, you have to establish impact. Not outrage, impact. Harry described moments where details of his private life appeared in print with unsettling precision. Not broad strokes. Specifics. Timing. Information that didn't feel guessable. And again, he was careful. He didn't claim certainty. He said appeared, seemed, gave the impression. That language matters. Because the defense is listening for absolutes, for claims that can be cornered, for statements that assume facts not yet in evidence. Harry, whether coached or cautious, avoided that trap. Instead, he allowed the discomfort to speak for itself. But here's where the tension really begins. Discomfort is not evidence. And the courtroom knows it. The defense's posture throughout Wednesday was one of calm skepticism. Not hostility. Not outrage. Skepticism. The kind that waits patiently for assumptions to reveal themselves. At one point, attention turned to the age of the articles in question. 2 decades, in some cases. A lifetime in media terms. The implication hovered unspoken. Why now? It's a question many viewers will ask themselves. Why return to stories long forgotten by the public? Why reopen wounds that have already scarred over? Harry's answers didn't land as a manifesto. They landed as a process. He spoke about understanding, over time, how certain practices worked. About connecting dots that weren't visible to him when he was younger. About realizing that what felt invasive might not have been accidental. That realization didn't arrive overnight. It accumulated. This is important because it challenges a common assumption that people always know when their rights are violated. In reality, power often obscures recognition, especially when the violator wears the badge of legitimacy. Ask yourself something uncomfortable. If a national newspaper publishes something true about you, but obtained through questionable means, would you know the difference? Or would you assume that truth validates method? That assumption is precisely what this case is interrogating. As Wednesday progressed, the court began to pivot away from emotional response toward inference. Harry was asked not just what he experienced, but why he believed unlawful activity was involved. This is where the ground gets slippery, because belief, no matter how sincerely held, must be anchored. Harry pointed to patterns, repetition, similar types of information appearing across different publications at different times with striking consistency. He described how private communications, movements, and conversations seemed to surface without plausible explanation. Still, he stopped short of naming mechanisms. No accusations of specific acts, no technical claims. He didn't say this happened. He said this led me to believe. The defense seized on that distinction. And here's the thing, they're right too. Legally, belief must be tested, especially when the accused party has issued a categorical denial, stating that its journalists did not commission or obtain information derived from illegal activity. That's not a vague rebuttal. That's an absolute one, which means the court is now balancing two very different kinds of certainty. On one side, lived experience, reinforced by pattern recognition and historical context. On the other, institutional denial, bolstered by time, documentation gaps, and the absence of contemporaneous complaints. Neither is frivolous. That's what makes this case dangerous. At several points, Harry was pressed on why complaints were not made at the time, why legal action wasn't pursued earlier, why these concerns only crystallized years later. His responses were telling, not defensive, reflective. He spoke about youth, about being overwhelmed, about lacking the knowledge, resources, or clarity to challenge powerful media organizations while under constant scrutiny. He suggested that the environment itself discouraged confrontation, that pushing back felt futile or even risky. This isn't a legal argument. It's a human one. But courts deal in law, not empathy. And the defense knows that, which is why Wednesday's testimony, for all its restraint, carried a quiet risk. Every acknowledgement of uncertainty is a gift to the other side. Every pause can be framed as doubt. Every, I believe, can be contrasted with I know. Yet, interestingly, the judge did not interrupt, did not rush, did not signal impatience. That silence matters. Judges ask questions when something doesn't add up. They stay quiet when they're listening. And what the court was listening for on Wednesday wasn't a smoking gun. It was coherence. Whether Harry's account, taken as a whole, made sense, even if individual elements couldn't yet be proven. This is where the slow-burn nature of the trial becomes apparent. Wednesday was not about conclusions. It was about framing the battlefield. Because over the coming weeks, this case will not hinge on one article or one allegation. It will hinge on whether a cumulative picture emerges. One that suggests more than coincidence, more than aggressive journalism, more than uncomfortable truth-telling. And the defense will do everything it can to fragment that picture, to isolate each story, each date, each claim, to insist that without direct evidence of illegality, inference is speculation. They will say, journalism is messy, sources are opaque, information travels in ways outsiders don't understand. And they're not wrong. Which brings us to the most unsettling aspect of Wednesday's proceedings, the possibility that no one is lying. That Harry genuinely experienced what he describes. That journalists genuinely believed their methods were legitimate. That editors genuinely saw no red flags. And that unlawful practices, if they existed, were so normalized, so indirect, so insulated by intermediaries that responsibility dissolved into the system itself. If that's the case, who does the law hold accountable? That question hasn't been asked out loud yet, but it's already shaping the trial. Because the court isn't just examining what happened to Harry. It's examining how accountability functions in large media organizations, especially when practices evolve faster than regulation and when scrutiny arrives decades late. Wednesday ended not with resolution, but with a narrowing of focus. The court began to hone in on specific articles, specific timeframes, specific claims that will be dissected in the days ahead. And that's when the real tension emerged. Because once you move from general patterns to particular stories, the stakes change. Details become traps. Memory is tested harder. Documentation matters more. And the margin for error shrinks. Harry knows this. The defense knows this. The court knows this. which is why Wednesday felt less like a confrontation and more like a prelude. A careful laying out of pieces before anyone tries to move them. As the room adjourned, ask yourself, if you are the subject of relentless coverage by a national newspaper, do you complain publicly? Or do you retreat? Do you challenge the institution amplifying your life? Or do you assume that resistance will only fuel the machine? Harry's testimony gestures toward the latter, toward a period where pushback felt pointless, where the press felt untouchable, where legality was assumed because illegality was unimaginable or unprovable. This isn't just about him. It's about a media environment that trained people to accept intrusion as inevitable. The court, however, can't operate on sociology alone. It needs specifics. That's why, as this section of the case unfolds, attention turns to categories of information. Not articles yet. Information. What kinds of private details appeared? Communications. Movements. Relationships. Conversations. Medical matters. Timing that suggests access, not inference. Each category carries different legal implications. Some information can be guessed. Some can be leaked by insiders. Some can be pieced together from public records. Others are far harder to obtain without crossing lines. The defense will argue that legitimate sources exist for all of it. Friends, staff, contacts, coincidence, journalistic skill. And in some cases, that may be true. But the claimant's argument is not that one source was illegitimate. It's that the volume and consistency of private information points toward a system where boundaries were repeatedly tested and sometimes crossed. This is where the trial's slow pace becomes essential. If this were rushed, nuance would be lost. It would collapse into caricature, prince versus press. But by stretching the proceedings over 2 months, the court is allowing something more granular to emerge. Pattern over time. Harry's legal team is expected to return again and again to this idea, not to prove one illegal act, but to show an environment where unlawful information gathering was part of the ecosystem. The defense, in turn, will insist that environment is an illusion, that journalists operated within the law, relying on sources whose methods they neither controlled nor questioned. And here's the uncomfortable truth. Both positions can coexist. A journalist can believe a source is legitimate without asking how the information was obtained. An editor can publish without probing too deeply. An institution can benefit from unlawful acts without officially endorsing them. The law has to decide whether that's acceptable. This is not an easy question, and it's why the court is proceeding with such caution. As this phase of the case unfolds, you can feel the tension tightening, not in raised voices, but in narrowed focus. The questions become more specific, the language more precise. The margin for narrative shrinkage grows. Harry is no longer just describing how things felt. He's being asked to justify why he believes lines were crossed, knowing that every answer will be weighed against institutional denial and the passage of time. And the defense is preparing its next move. Because once accusations are fully laid out, the next step is to dismantle them piece by piece, article by article, claim by claim, memory by memory. This is where things get uncomfortable for everyone. Because the closer the court gets to specifics, the harder it becomes to hide behind generalities. And the more dangerous uncertainty becomes. The accusation has been made. Clearly, calmly, under oath. Now the question is whether it can survive contact with detail. And that's where the trial is headed next. Into the granular territory where belief meets documentation and where absence may be interpreted as innocence or concealment. And once the court starts pulling on those threads, there may be no way to control what unravels. If accusations are the spark, detail is the oxygen. And once the court moves into detail, the air gets thin fast. Because this is the moment where broad claims stop being persuasive on their own and start demanding structure. Dates, articles, sequences. The sort of specificity that doesn't care how compelling a narrative feels, only whether it holds under pressure. That shift happened almost imperceptibly. No announcement, no formal pivot, just a gradual tightening of the lens until the courtroom was no longer talking about the press or media culture, but about individual pieces of journalism that existed on specific days, with specific claims aimed at a specific person. This is where many cases stumble. General patterns are easy to describe. Granular proof is not. The court began examining how these stories were selected. Why these articles and not others? Why these periods? Why these themes? It's not enough to say this happened often. The law wants to know, often compared to what? Harry's team isn't throwing everything into the record. That would be chaos. They are curating, selecting examples they believe are representative, not extreme outliers, not borderline cases, but articles that, in their view, illustrate something systemic. And that selection process matters more than most viewers will realize. Because every article included invites scrutiny not just of content, but of plausibility. Could this information have come from a legitimate source? Is there a lawful explanation that doesn't require unlawful activity? Does coincidence suffice? Or does repetition demand something more? These are not emotional questions. They are mechanical. Harry, answering under oath, was asked to walk through his reasoning slowly, to explain why certain details stood out, why timing mattered, why the specificity felt different from ordinary reporting. He didn't rush. In fact, at times, he seemed to pull back, as if aware that overstating the case would do more harm than good. That restraint is easy to miss, but it's crucial, because one of the defense's quiet strategies is to let the claimant talk, to allow assumptions to surface naturally, to wait for moments where inference stretches too far. So far, those moments haven't arrived. Or if they have, they haven't been dramatic enough to derail momentum. Instead, what's emerging is something more uncomfortable. A picture of journalism that may have operated within the letter of the law while drifting perilously close to its edge. And here's where the contradiction sharpens. The publisher insists that its journalists did not commission or obtain information derived from illegal activity. That statement, on its face, is clean. But it leaves open a question the court will eventually have to confront. What responsibility does a publisher have to interrogate how information reaches them? Is ignorance a defense? If a journalist receives information that appears unusually precise, private messages, confidential movements, sensitive conversations, are they required to ask how it was obtained? Or is it enough that the source presents it confidently? In practice, newsrooms often rely on trust, on relationships, on assumptions built over time. Challenging a source too aggressively can mean losing them. And losing sources means losing stories. That incentive structure is not illegal, but it can create blind spots. Harry's case doesn't accuse journalists of knowingly breaking the law. It suggests something more insidious, that unlawful practices may have been tolerated indirectly because the results were valuable and the risk felt abstract. That's a hard thing to prove, and even harder to defend against. Because how do you demonstrate diligence retroactively? How do you show what questions were asked or not asked 20 years ago? The defense leans heavily on the absence of evidence. No records of commissioning unlawful acts. No documentation of payments for illegal activity. No complaints filed at the time. But absence cuts both ways. If unlawful practices occurred, they were unlikely to be documented openly. That's the nature of illegality. And if subjects didn't complain, whether out of fear, ignorance, or resignation, the silence becomes ambiguous. This is where the judge's role becomes critical. The court is not tasked with reconstructing history perfectly. It's tasked with determining whether, on the balance of probabilities, unlawful activity occurred and whether the publisher bears responsibility for it. That standard is lower than beyond reasonable doubt, but higher than suspicion. So every detail matters. Harry was asked to identify moments where information appeared that, in his view, could not plausibly have come from public sources or friendly leaks. He pointed to patterns of timing, stories appearing shortly after private conversations, or following movements that were not publicly known. He did not claim exclusivity. He did not say only one paper published such details. But he emphasized consistency, a repetition that, over time, felt less like chance and more like access. This is where the defense's counterargument looms. Journalists will say that insiders talk, staff talk, friends talk, that information spreads organically, especially around high-profile figures, that what feels private to the subject may feel accessible to those around them. And again, that may be true. The court isn't being asked to decide whether leaks exist. It's being asked to decide whether unlawful methods were used or commissioned. That distinction is subtle, but it's the spine of the case. As questioning continued, the atmosphere remained controlled. No visible frustration. No overt hostility. But you could feel the stakes rising. Because once you start dissecting individual articles, the margin for error narrows. If one key example collapses under scrutiny, if a plausible lawful explanation emerges, it weakens the pattern argument. Not fatally, but perceptibly. The defense knows this. That's why they are likely to focus on alternative explanations for each instance. Not to disprove everything, but to introduce enough doubt that the cumulative picture blurs. Harry's task, then, is not to be perfect. It's to be consistent. And consistency, over hours of testimony, is hard. Fatigue sets in. Memory strains. The temptation to fill gaps grows. The courtroom becomes less forgiving. So far, Harry has avoided speculation. He has repeatedly acknowledged what he does not know. That humility plays well legally, even if it frustrates those looking for fireworks. But humility has a cost, because every admission of uncertainty gives the defense room to maneuver, to suggest that what feels invasive might simply be uncomfortable truth, that what appears systematic might be coincidence amplified by hindsight. This is the tension the court will live in for weeks. And it's why this case is so difficult to reduce to headlines. Is it possible that unlawful information gathering occurred without leaving a clear trail? Yes. Is it possible that journalism was aggressive but lawful? Also yes. The court's task is to decide which is more likely, based not on outrage, but on inference drawn from evidence and absence alike. As this phase of the trial unfolded, it became clear that the real battleground isn't whether Harry felt violated. That's almost beside the point. The battleground is whether the mechanisms of journalism, as practiced at the time, created conditions where illegality could flourish without detection, and whether publishers can be held responsible for that environment. That's not just a question for this case. It's a question for the industry. And that's why so many observers are watching quietly. Not cheering. Not jeering. Watching. Because if the court decides that publishers have a duty to look harder at how information is obtained, even when sources seem legitimate, it changes the calculus of reporting. It introduces friction. It slows things down. Some will call that accountability. Others will call it a chilling effect. The judge will eventually have to navigate that tension. For now, the courtroom remains focused on the immediate task, testing the allegations against the reality of evidence. As Wednesday gave way to subsequent sessions, the direction was set. The trial would move deeper into specifics, into records, into timelines, into the uncomfortable space where memory is weighed against documentation. And this is where things could turn. Because once documents are introduced, or their absence highlighted, narratives harden, positions crystallize, and the quiet accumulation of detail either coheres into something convincing or collapses under its own weight. The accusation has been articulated. The defense has denied it in absolute terms. Now comes the phase where one of those positions will start to feel more fragile than the other. And when that happens, it won't be announced. It will reveal itself slowly, in the judge's questions, in the narrowing of focus, in the moments where one explanation starts to strain. That's what the next stage of this trial is about. And once the court steps fully into that terrain, there may be no way back to abstraction. Because detail doesn't just clarify, it exposes. At some point, every long case reaches the same moment. The point where memory stops being enough. Where lived experience, no matter how sincerely described, has to give way to something colder, harder, less forgiving. Paper. This is the phase the courtroom began drifting toward next, even if no one said it out loud. Because once patterns are alleged and specifics are selected, the inevitable question follows. Where is the record? Not the headlines. The internal trail. Notes. Logs. Messages. Invoices. Anything that shows how information moved from private space to printed page. And this is where the case becomes genuinely uncomfortable, not just for the claimant, but for the institution defending itself. Because records age poorly. They disappear. They're overwritten, archived, destroyed according to policies that made sense at the time. And when a case arrives decades later, absence becomes the dominant feature of the landscape. Which raises a question the court can't avoid for much longer. When records are missing, who benefits? Harry's testimony, up to this point, has lived in the space between what he experienced and what he believes that experience implies. The defense has allowed that space to exist, quietly confident that implication alone won't carry the day. But now, as the court edges toward documentation, the terrain shifts again. Because documentation doesn't just support claims, it constrains them. Harry was asked, carefully, about what he could point to beyond recollection, not to trap him, but to clarify the limits of his case. What emails had he seen? What records had been preserved? What evidence existed beyond the articles themselves? His answers were honest and limited. He does not have access to newsroom records. He does not possess internal communications. He cannot produce logs of who spoke to whom or how information was sourced. That asymmetry is obvious and unavoidable. The defense, by contrast, has institutional access, or at least it once did. And this is where the silence in the record becomes loud. Because the publisher's position rests on a clean narrative, responsible journalism, legitimate sources, no illegal activity commissioned or obtained. If that's true, one might expect some trace of that legitimacy, some documentation of sourcing practices, some evidence of due diligence. But much of that material, if it ever existed, may no longer be available. This is not unusual. Newsrooms are not archives designed for litigation 20 years down the line. Retention policies expire. Data storage evolves. Systems are replaced. Still, the court has to ask, is the absence of records neutral, or does it tilt the balance? Legally, absence alone is not proof of wrongdoing. But context matters, especially when the allegations concern practices that, by their nature, would avoid documentation. This is the paradox at the heart of the case. If unlawful information gathering occurred, it likely left little trace. If it did not occur, the lack of trace is equally explainable. Both sides can point to the same void and draw opposite conclusions. So the court looks elsewhere. It looks at timing, at consistency, at the plausibility of lawful explanations across multiple instances. It asks whether coincidence can reasonably bear the weight placed upon it. Harry's team understands this. That's why they are not overreaching. They are not claiming a grand conspiracy. They are not alleging a single orchestrated scheme. They are pointing to an environment, one where incentives, competition, and distance from sources may have created conditions where unlawful acts could occur without direct oversight. That framing is deliberate. It shifts the question from who broke the law to who is responsible when the law is broken indirectly. The defense will resist that shift fiercely. Because responsibility, once diffused, becomes dangerous. If publishers are held accountable not only for what they know, but for what they should have known, the implications extend far beyond this case. Every newsroom operates with some degree of opacity. Sources are protected. Methods are guarded. If courts begin to scrutinize that opacity retroactively, the ground moves. The judge knows this, which is why the approach remains methodical. As sessions continued, questions circled back to the same themes from different angles. Not repetition, triangulation. The court probing whether Harry's conclusions remained consistent when tested against different hypotheticals. Could the information have come from staff? From friends? From chance encounters? From lawful investigative work? Harry acknowledged those possibilities, but returned to pattern. Not one article, not two, but many, over time, with similar types of detail. He wasn't asking the court to accept certainty. He was asking it to accept probability. That's an important distinction. The defense, meanwhile, will push the opposite narrative, that journalism, especially around high-profile figures, produces clusters of information that feel invasive precisely because interest is intense. That coincidence looks like conspiracy when viewed from the inside. Both arguments have force, which is why the court's attention is drifting towards something less subjective: institutional practice. How were stories sourced, generally? What policies existed? What guidance did journalists receive? How were ethical boundaries communicated? Even if specific records are gone, general practice can still be examined. This is where the publisher's assertion of responsible journalism will be tested, not rhetorically, but structurally. What does responsible journalism mean in operational terms? Does it require asking sources how information was obtained? Does it require refusing material that appears too intrusive? Or is responsibility satisfied once information appears credible and newsworthy? These questions don't have obvious answers. They evolve over time. But the court has to decide what standard applied and whether it was met. And here's the complication. Standards themselves were shifting during the period in question. The early 2000s were a transitional era. Competition was fierce. Regulation lagged. Public awareness of press intrusion was growing, but not yet crystallized. Practices that might now raise immediate red flags were then tolerated, even celebrated. Does that context excuse conduct? Or does it merely explain it? The defense will argue the former. Harry's team, the latter. As this phase unfolds, you can sense the trial narrowing its aperture. Less about Harry as an individual, more about the machinery around him. If what happened to him was typical, the argument goes, then it can't be illegal. Or at least, it can't be uniquely so. But normality is not a defense to unlawfulness. History is full of practices that were normal until they weren't. This is where the weight of other scandals, unspoken but present, presses on the room. The court doesn't need to reference them. Everyone knows they exist. Everyone knows that certain things once dismissed as implausible turned out to be real. That history doesn't decide this case, but it informs how plausibility is assessed. The defense's use of the word preposterous now feels like a calculated risk, because once something has happened before, calling it unthinkable carries less force. At the same time, the claimant can't rely on past scandals to prove present claims. Each case stands on its own. So the trial advances, inch by inch, toward a point where the judge will have to choose which uncertainty feels more acceptable. The uncertainty that unlawful acts occurred but cannot be fully traced, or the uncertainty that lawful journalism consistently produced results that feel indistinguishable from unlawful intrusion. As observers, it's tempting to look for turning points, moments where the tide shifts. But real trials rarely offer those on cue. Instead, they accumulate weight, and weight, eventually, tips something. We're not there yet, but the balance is becoming visible. As the court prepares to move further into examination of specific practices and broader industry standards, one thing is clear: abstraction is no longer enough. Generalities are being retired. What comes next will demand sharper answers, clearer positions, and explanations that can withstand sustained scrutiny. Because the longer this trial runs, the harder it becomes to hide behind ambiguity. And once ambiguity starts to feel like avoidance, the court's patience will end. That's when the real pressure begins. And when it does, not everyone will be able to maintain the calm they've relied on so far. That moment is coming. And when it arrives, it won't announce itself loudly. It will arrive as a question that no one is quite ready to answer. There's a moment in every long trial when the atmosphere changes, even though nothing obvious happens. No raised voices, no dramatic objection, just a subtle recalibration in how questions land and how answers are received. This is that moment, because the court has now heard enough to stop asking whether unlawful activity is conceivable and start asking something more precise. If it happened, how would we even know? That question hangs over everything that follows. Up to this point, the case has lived comfortably in the realm of inference. Patterns, probabilities, plausibility, but inference has limits. And the law, eventually, demands traction, something it can lean on without slipping. So the focus tightens again, this time on mechanisms. Not specific crimes, not specific perpetrators. Mechanisms. How information moves, how stories are built, how boundaries are monitored or not. This is where Harry's testimony becomes less about his personal experience and more about what his experience reveals, unintentionally, about the structures around him. He is asked, again, to clarify how he distinguishes between lawful intrusion and unlawful gathering. Not philosophically, but practically. What tipped the balance for him? The answer isn't a single moment. It's a gradual recognition that some stories contained information that didn't behave like gossip. It arrived too cleanly, too completely, without the usual errors or gaps you'd expect when information is secondhand. That may sound subjective, and it is, but subjectivity is not automatically irrelevant. Courts weigh it all the time, especially when objective records are missing. Still, the defense presses on. They suggest that what feels too precise may simply reflect good reporting. Persistent questioning, cultivated networks, people talking when they shouldn't, but not illegally. And again, that explanation has force. This is where the contradiction sharpens. The better journalism is, the more it can resemble intrusion. Excellence and excess start to blur. So the court has to ask, at what point does skill become suspicion? This isn't a rhetorical question. It's a legal one. The judge's task is not to protect journalism from discomfort, nor to validate discomfort as evidence. It's to decide whether, given everything presented, the claimant has crossed the threshold from feeling violated to showing probable unlawfulness. And that threshold is narrow. Harry's legal team understands this. That's why they've avoided grand claims. They're not asking the court to condemn an industry. They're asking it to scrutinize a pattern and decide whether it reasonably points to something more than aggressive reporting. The defense, in turn, is trying to keep the focus diffuse, to prevent any one example from becoming emblematic, to remind the court that complexity is not culpability. But complexity can also be camouflage. This is where the judge's questions begin to matter more than the lawyers. When judges start asking about process, not outcomes, it's a sign they're probing responsibility. Who was supposed to notice? Who was supposed to intervene? Who had the power to say no? Those questions don't require proof of a crime. They require proof of oversight, or the lack of it. The defense will argue that journalists are not detectives, that they are not required to investigate their sources, that imposing such a duty would fundamentally alter the press's ability to function. The claimant's counter is quieter. That responsibility does not require omniscience, only reasonableness. That when information repeatedly crosses into deeply private territory at speed, without obvious lawful explanation, a responsible institution should pause. This is the heart of the dispute, and it's why this case is so finely balanced. Because the court is being asked to draw a line that hasn't been clearly drawn before. To say, here is where acceptable journalistic practice ends and unlawful intrusion begins. Even when the boundary is obscured by time and missing records, that's a heavy burden. As proceedings move forward, you can sense an underlying anxiety on both sides. For Harry, because the further the case moves from his lived experience and into institutional analysis, the less control he has over the narrative. His role becomes symbolic, not evidentiary. For the publisher, because institutional analysis invites scrutiny that goes beyond individual journalists. It raises questions about culture, incentives, and blind spots, things that are hard to deny without sounding evasive. This is why the defense continues to emphasize the absence of contemporaneous complaints. No one objected at the time, they say. No legal challenges were brought. That silence suggests acceptance. But the court is not obligated to accept that framing. Silence can mean many things. It can mean ignorance, fear, exhaustion, or a belief that resistance is futile. And when the subject is young, isolated, and under relentless scrutiny, those explanations gain weight. Still, weight is not proof. The court remains cautious. What's becoming clear, though, is that this case will not be decided by a single revelation. There will be no moment where everything suddenly makes sense. No document that settles the matter. Instead, the judge will have to decide which story feels more coherent when all the gaps are accounted for. Does it make more sense that a major newspaper group consistently obtained highly private information through lawful means alone, even when those means are hard to trace? Or does it make more sense that, in a competitive and lightly regulated environment, unlawful practices occasionally seeped into the process, leaving behind effects but not records? Neither conclusion is comfortable, and the court's discomfort is visible in its pace. This is not a judge rushing to judgment. This is a judge mapping consequences, because whatever he decides will echo. If he sides with Harry, media organizations will have to reckon with the idea that patterns and probabilities can ground liability, even decades later. If he sides with the publisher, it signals that without direct evidence, institutions remain insulated, even when patterns raise suspicion. That signal will shape behavior. And that's why this phase of the trial feels so consequential, even though it's low on drama. The courtroom is now less interested in what happened to Harry than in what his case implies. About accountability, about memory, about the limits of proof. As the questioning prepares to move further into institutional practice and expert testimony, one thing is becoming unavoidable. This case will turn not on certainty, but on judgment. And judgment is influenced by what seems reasonable in context. The defense is betting that reasonableness favors them, that the court will hesitate to impose liability without clear evidence of illegality. The claimant is betting that reasonableness cuts the other way, that the court will not accept repeated intrusion as mere coincidence. That bet hasn't been resolved yet, but the stakes are now fully in view. Because once the court moves beyond what Harry remembers and into what the industry tolerates, the implications stretch far beyond one lawsuit. And the closer we get to that territory, the harder it becomes to pretend this is just another celebrity case. It isn't. It's a test of whether the law can meaningfully confront systems that leave no fingerprints, and whether absence, in the end, will be treated as innocence or as the very thing that demands scrutiny. That question is no longer theoretical. It's now sitting squarely in front of the court, and the next phase will force it to answer. By the time the court reaches this stage, something else has quietly happened. The burden has shifted, not formally, not legally, but psychologically. Because once a judge has listened to hours of testimony about patterns, probabilities, missing records, and institutional practices, the question stops being, has this been proven? And becomes, what would make sense here? That's a dangerous moment in any trial. Not because judges act on instinct, they don't. But because sense-making is unavoidable when evidence is incomplete. And this case is saturated with incompleteness. The courtroom is now wrestling with a paradox it can't escape. The very practices being alleged are the kind that, if they existed, were designed not to leave a trace. Which means the absence of proof can't simply be treated as neutral. But it also can't be treated as incriminating. So the court turns to something else. Credibility, not just of the witness, of the explanations. At this point, Harry's testimony is no longer the center of gravity. It's the reference point. The court has heard his account. It understands his position. Now it is testing whether the alternative narrative, the publisher's narrative, holds up under the same pressure. And that narrative is deceptively simple. We practiced responsible journalism. We relied on legitimate sources. We did not commission or obtain information derived from illegal activity. These stories were published long ago. No complaints were made at the time. On paper, that's solid. In practice, it raises questions the defense would rather not linger on. Because legitimate sources is a conclusion, not a description. Who decides legitimacy? At what point? Based on what criteria? Journalism, especially in the period being examined, operated on trust networks. A source who delivered consistently was a good source. A source who produced results was valued. Their methods were often not interrogated unless something went visibly wrong. This wasn't negligence. It was culture. And culture is notoriously hard to put on trial. The defense wants the court to accept that culture as normal, as a reasonable context for the time. The claimant wants the court to see that same culture as permissive, as one that allowed boundaries to blur. Neither is obviously wrong. This is why the judge's silence has become so important. Judges don't fill silence unless they need to. When they stay quiet, they're often testing which side is more comfortable living with unanswered questions. And right now, those questions are multiplying. If the publisher's journalists did not commission illegal activity, how did they ensure that? What safeguards existed? What questions were asked when information seemed unusually intrusive? The defense can say, truthfully, that journalists are not required to interrogate sources like investigators. That source protection is fundamental. That demanding proof of legality would paralyze reporting. All of that is correct. But the claimant's case doesn't require omniscience. It suggests reasonableness. That when certain red flags appear repeatedly, timing, specificity, volume, a responsible institution should notice. The court is now testing that idea without naming it. Through hypotheticals, through quiet reframing, through asking the same question in different ways. At one point, attention returns to the idea of commissioning, not as a literal instruction to break the law, but as a system of incentives. What happens when journalists are rewarded for results without scrutiny of methods? What happens when distance from illegality becomes a feature, not a flaw? This isn't an accusation. It's an inquiry. And inquiries are harder to deflect. The defense's response, again, is to emphasize boundaries. That journalists did not ask for illegal acts. That they did not direct sources to do anything unlawful. That they received information as it was offered. That distinction may satisfy criminal law. Civil law is less forgiving. Because civil responsibility can attach not just to actions, but to failures of oversight. This is where the case becomes genuinely unsettling for media organizations watching from the sidelines. If the court decides that turning a blind eye, even unintentionally, is not enough to avoid responsibility, then the ground shifts. It introduces a duty to notice patterns, to ask uncomfortable questions, to risk losing stories. That's not a small change, which is why the defense will resist it at every turn. They will argue that such a standard is unworkable, that it asks journalists to become investigators of their own sources, that it undermines the very mechanism by which information reaches the public. They will say that this case, if successful, would open the floodgates to retrospective litigation. Every invasive story re-examined decades later, every newsroom practice second-guessed. Those concerns are real. But the claimant's side has its own answer. Accountability is not retroactive punishment. It's recognition that power carries responsibility, even when exercised indirectly. The judge is now standing between these positions, and you can feel the weight of that responsibility in how cautiously the proceedings are unfolding. No one is rushing. No one is grandstanding. This is not about winning the day's headlines. It's about laying foundations for a ruling that will have to survive appeal, scrutiny, and history. That's why the trial is structured the way it is, why it stretches into late March, why a ruling won't come immediately. The judge is building a record robust enough to support whatever conclusion he reaches, and that means asking questions that don't have satisfying answers. As this phase continues, the courtroom begins to feel less like a battleground and more like a laboratory. Hypotheses are tested, variables isolated, outcomes considered. Harry's role, now, is almost complete. He has set the inquiry in motion. He has described the effect. He has pointed to the pattern. The rest will be decided without him. That's an uncomfortable truth for viewers who expect justice to be personal. It isn't. It's structural, and structure is indifferent to emotion, which is why the defense appears increasingly calm. Not complacent, calm. They know that courts are conservative institutions. They prefer clear rules. They hesitate to expand liability without firm grounding. The claimant is asking the court to do something subtle but significant. To recognize that illegality can exist without fingerprints, and that institutions can benefit from it without direct participation. That's a difficult ask. But difficulty does not equal impossibility. As the case moves toward expert testimony and deeper examination of industry norms, the judge will have to decide how much weight to give context, how much to excuse because that's how things were done, and how much to hold accountable because that's no longer acceptable. The line between explanation and excuse is thin, and the court is now standing directly on it. Nothing dramatic will announce when the balance tips. There will be no sudden revelation, no confession, no document pulled from a dusty drawer. Instead, the decision will emerge gradually, in the way the judge frames the remaining questions, in the issues he presses, in the arguments he lets breathe, and those he cuts short. Those signals are coming. And when they do, observers will start to sense which narrative the court finds more coherent. Not more compelling, more coherent. Because coherence is what judges rely on when certainty is unavailable. The trial is now deep into that territory. And as it moves forward, one thing is becoming clearer by the day. Whatever the outcome, it will say less about the past than it will about how the law chooses to confront power when proof has faded but suspicion remains. That choice is approaching. And when it arrives, it will not offer comfort. Only consequence. There's a point in proceedings like this when the courtroom stops talking about what happened and starts asking who was supposed to notice. It's a subtle turn. Easy to miss if you're listening for drama. But it's the turn that matters most. Because responsibility doesn't always attach to action. Sometimes it attaches to omission, to what wasn't asked, to what wasn't challenged, to what slid by because no one wanted to be the person who slowed the machine. This is where the trial is now living. Up to this moment, the defense has leaned on deniability, not aggressive denial, measured, professional, almost serene. No illegal activity commissioned, no information obtained unlawfully, legitimate sources, responsible journalism. Each phrase is clean. Each phrase is defensible. And yet, when placed side by side with the lived experience described in court, they begin to feel incomplete. Not false, incomplete. That distinction matters. Because courts don't require perfection. They require sufficiency. And sufficiency depends on whether an explanation accounts for all the relevant facts, not just some of them. What's emerging now is a tension between two kinds of reasonableness. The defense's reasonableness says, journalists cannot be expected to police their sources. The claimant's reasonableness says, institutions cannot repeatedly benefit from deeply private information without asking how it's being obtained. Both positions are rational. The court has to choose which one better aligns with legal responsibility. This is not an abstract debate anymore. It's being tested in the specifics of newsroom practice. How were stories pitched? How were they approved? What questions were considered routine? What raised eyebrows, and what didn't? These questions don't require records of wrongdoing. They require testimony about culture. And culture is where accountability often hid.